Hey, all.
Hi.
Hello.
We have 1, 2, 3, 4.
So I know Roger's going to try to jump on, but since Tom, this is just kind of an informal training of sorts. You technically have enough to get started, right, Jennifer? He just needs 3. So, and Britt's going to do roll call for us tonight.
Great. Okay, I call the meeting the December 5th Board of Zoning Adjustment to order. Can we get a roll call, please, Brett?
Yes. And sorry if I butcher some names. I am still very new.
Let's do board training. You're going to get trained too.
Awesome. So I have David I'm sorry, McVeigh. Did I say that?
McElvain.
Okay. Okay.
And he's here.
Okay. Steve Cepak.
CPAC, yeah, here.
Ryan Villion.
Here.
Roger Cornell.
Not here yet,
Not yet.
but maybe soon.
Okay. And Tom Hall.
Oh, Tom was there.
Yeah.
He was just here.
I know,
I
what
don't know.
happened?
Mark
Where did
Mall
Tom
is
go?
not going to be here tonight.
I don't know where we lost Tom.
Uh-oh.
I don't know, Jennifer, I think we lost Tom in some fashion. Do you want to this is really meant for the 3 who are here because it sounds like there's a possibility Tom might transition off as the trustee liaison. So you've got, oh, he's back.
Here comes.
Maybe. Tom.
I'm here.
There we go. All right, that's better.
Okay.
I'll go ahead and start sharing my screen.
Well, no, we have to approve minutes. We've got some other.
Okay. Sorry,
really
I
short-
didn't see the
The
agenda.
world's shortest minutes I've ever done. They were 1 page, and I crammed the signature line just so I could get it down to 1 page. It was
Yeah, and I think you're still at 12-point font too.
I am. It was the best.
No, that was the
These
best
are so easy.
22-minute long meeting ever.
I know. It was incredible. So.
But best of all, they're accurate. So I make a motion to approve the minutes from this is our last. Let's see, our last meeting was November 21.
Was it that long ago?
No, December. Those are December minutes.
Yeah, that was
They're
December 5th.
Oh, I'm sorry. Yeah, you're right. Yeah, I was looking at the minutes, and which were referring back to the previous minutes.
Yeah.
December 5th.
Yeah.
Yeah.
I second.
Call the vote, please.
Aye.
I guess let's just put our hands up if we approve.
Look at that.
Good. Okay, then
I like the way this board is functioning.
That's great. Okay, let's see. So those are approved. Then we move on to public comment on non-agenda items. There's nobody in the room because there is no room. There's nobody else online, right?
Nope.
Okay. So we're item 4 is complete. And we can move on to discussion item there's only one tonight, 5.1. Do you want to set it up, Miranda?
Sure. So Attorney Madsen is here with us tonight. The purpose of this was because we have 3 brand new members, was to really kind of go over what it means to be on the Board of Zoning Adjustment, some considerations that you should be mindful of when reviewing variance applications, and other words of wisdom from Attorney Madsen.
Thank you, Miranda. I will go ahead and share my screen here. Can you all see it?
I can. No, it's coming.
Oh,
There we go.
Okay, great. Well, let me introduce myself first. I'm Jennifer Madsen, and just so you all know how I work with the town, I am hired by the Board of Trustees. So the Board of Trustees is my main client. But I also support town staff. I work very closely with Miranda Fisher, help on any legal issues that she may need. And then I also support the other boards and commissions, and it's primarily the Planning Commission and the BZA. So as Miranda mentioned, I've got a training for you tonight. I would like this to be really informal. So if you have questions as we go along, please do feel free to interrupt me and ask your questions. Okay, so an overview of what we're going to talk about tonight. First, we're going to look at the law that forms the basis for the Board of Zoning Adjustment. Then I'm going to cover the process for applications for variances. The most of the discussion tonight, the majority of the discussion will be focused on the conduct of hearings before the BZA. Next, I'll talk about the ex parte rule, and lastly, I'll go into conflicts of interest. So Colorado law actually requires that municipalities do have a Board of Zoning Adjustment. It's in the municipality section of the statutes. The law requires that there be 5 members to the BZA and that those 5 members serve 3-year terms. Now, the statute provides that the governing body can adjust those terms and can allow for alternate members. State law requires that there can be appeals from the decisions of the BZA. It requires a vote of 4 members of the BZA to approve any action. And then also the decision may be reviewed by the district court. So just for clarification, what I meant related to appeals from administrative decisions, the BZA really has 2 functions. One of those functions is what you all have been looking at over the last several months, and that is to review variance requests from your property owners in the town. So property owner wants to do something different from what the code allows, and they come to you and ask for a variance. The other function that you have is an appeal from an administrative decision. So a decision by your zoning administrator in carrying out the functions of the code. Now, I have been with the town since 2019, and I'm not aware that any of those appeals have come to you. So that's something that would be very rare for you to consider. The Nederland Municipal Code also has specifications related to the BZA, and that is that there must be 5 members, and one of the members can be a member of the Planning Commission, and all have to be residents of the town. The code allows for 5-year terms, and the Nederland Municipal Code is consistent with state law that you need a vote of 4 members on any decision. So next I'm going to go into the process for the applications. And these are applications for variances. What happens first is a property owner comes to the town and submits an application to the zoning administrator. A lot of times there's conversations before this happens, and back and forth between Miranda and the property owner as to how the code applies to what the property owner wants to do. With their application, the property owner must pay a fee and then also pay an escrow amount in addition to the fee. And the escrow amount is really for review by me and any other professional, maybe an engineer, JVA, who needs to review the variance application. A hearing date must be set within a reasonable amount of time. And once the hearing date is set, the code provides that a mailing of notice needs to be provided to the adjacent property owners. And Miranda, just a question for you on this. How do you determine who are the adjacent property owners?
Sorry, I'm trying to get Roger into the meeting, so I had my volume turned down. Will you repeat that?
Yes. So I was wondering, in the code, it requires mailing of the notice of hearing to the adjacent property owners. And I think it might be helpful for the members of the BZA to know who are the adjacent property owners. How do you come up with that?
So, yep, there are any property owners within 300 feet of the property boundary. So we're going to draw a boundary line around the property, and then on Property Viewer, it will pull any address within the 300 square foot range.
Okay, so that's kind of an interpretation that's been made as to what adjacent means. And there is the 300-foot provision in other areas of the code. So, town is really being consistent in providing notice of the hearing. Then in terms of the process, you have your hearing before the BZA. And the last step is that a reasonable time from the hearing, the board must issue a decision. So you don't have to issue a decision the same night as your hearing, and a decision can be issued, say, at the next meeting. I think it's also very important for you to know that part of the process can be what happens after you issue a decision. One of the first things that it's good for you to know is that the Board of Trustees never sees your decisions. They don't have an opportunity to review, and there is no appeal right for the property owner to the Board of Trustees. A property owner or a neighbor really can appeal a decision of the BZA to the district court. So that would be to the Boulder County District Court that an appeal is made to. The district court would then look at the record that is before the BZA, and if the facts are supported. So what they would look at is they would look at your resolution, and they would look at all of the information that's in your record. And I'll talk about that a little bit later, what your record is. But the district court is really reviewing the decision to determine whether the BZA abused its discretion or exceeded the jurisdiction. And those are legal terms that really mean, did you follow your criteria in reviewing this application? Was your decision supported by the information that was provided to you at the hearing? And was your decision decided based on other factors not in evidence or not part of the criteria? Say that a decision was made because you are best friends with the property owner, and that's the basis for your decision. And then if a neighbor appeals that, that neighbor would likely have strong grounds for a reversal.
Attorney Mattson, a couple of questions. In your tenure, have any decisions from BZA gone to district court? And
No.
if you do get to district court, it's a judge, right? An administrative judge?
It's an actual district court judge. So
Okay.
it is a district court judge who would be deciding the issue. Nederland has not had any appeals that have been filed with the district court judge. And none of the other quasi-judicial cases have been appealed to a district court judge.
Okay.
So it is fairly rare, but what we want to do is make sure that we have the best record, that the findings and decision is based on the evidence that is presented and based on the criteria, so that if, you know, it's that one case that is appealed, we have a good standing to have the decision upheld.
Okay.
Okay, so now, like I said, the bulk of the training is going to be focused on the conduct of the hearing. And the first part of this that's really important for you all to know is, what type of decision is this that you are making? And when we are talking about government bodies who make decisions, there are several different types of decisions. One type of decision is a legislative decision. Then you have quasi-judicial actions. And then the third type is an administrative decision. A legislative decision, if you think about that, that is a decision that affects the entire community. It's rules that are made and standards that are put into place that that apply to everybody. And so one example of that is the Town Zoning Code, Chapter 16, which you all work with for the variances. A decision as to how high a fence can be in town, how high a building height can be in town, that is a legislative decision. Quasi-judicial decisions involve decisions related to specific property owners, to individuals. And David, I see have your hand up.
Just a quick question. I know this has never gone to a court appeal, but were that to happen, would we have to appear in court?
No.
Oh, okay.
So what happens if there is an appeal is that basically it's done on the record that was before you. So we package everything up. We'd probably have to transcribe the hearing. We'd have to hire a court reporter to transcribe the hearing. And whoever is bringing the appeal would have to be making some arguments as to why they have grounds for the appeal. And then the decision would be based really on legal briefing, you know, written documents arguing. One side would argue that there was maybe insufficient evidence, say, to approve the variance. And then I would be responding, no, there was sufficient evidence. Judge, look at page 32 of the hearing where the neighbor testified that, or I don't know, that the property owner said that the condition of the property was such that a structure could not be built within the setbacks, behind the setbacks. Does that make sense?
It would be some factual evidence. They wouldn't be wanting to know what our thinking was in making that decision.
No, except for the fact that your deliberations would be part of the record. So your deliberations in the hearing would be part of the record. And the resolution that you approved or didn't approve the variance would be part of the record as well. And that would include your reasoning for reaching your decision.
Okay, that covers it. Thank you.
So the quasi-judicial actions are related to specific individuals, specific property owners, and it involves a determination of rights and obligations related to that specific property owner, and it's based on an application. With a quasi-judicial action, you do have notice provided to the individual and to other property owners, and then you have a hearing. And essentially, quasi-judicial actions are looking at the specific facts of that request and applying the criteria to those specific facts. So quasi-judicial actions, they have constitutional protections for these decisions. The individuals who are involved have due process rights under the Constitution. And those protections are that you as judges cannot prejudge or be biased on an application. There must not be ex parte communications, and I'll talk a little bit later about what that means. And your decisions must be based on the record and information before you. One way that I like to tell people to think about quasi-judicial actions is think about it as a court process, as a judge. You know, you're in a role and you're judging this application based on the facts that you have before you. So when you think about, you know, maybe if you have a question, should I do this or not? Think, is that something that you would expect that a judge would do? Any questions on quasi-judicial?
So far, so good.
Good. Okay. So then we'll go into the specific format of the meetings. The chair opens a meeting and just lays out the format of how the meeting and the hearing is going to happen. And that is that staff presents the application. Once staff has presented the application, then the BZA members ask questions of staff. Right now that the meeting is open, really you're in your fact-finding part of the hearing. So you are now trying to take in all the evidence and gather information. So you're only asking questions of staff and you're not making opinion statements. This is important because you haven't heard all the evidence at this point. You don't know what the applicant is going to say, and you don't know what the public is going to say. So any opinions that are shared at this point, even though you might have a feeling or you might have some thoughts as to which way you're going to decide this issue, it's really important not to share those at this point, because then it looks like you prejudge the application because you haven't heard all of the evidence yet. So that's why I strongly recommend no opinions before you have heard all of the evidence. So after the staff presents and you ask questions of the staff, then the applicant has an opportunity to present, and you can ask questions of the applicant. Then you have public comment. You can definitely ask members of the public questions. If you have follow-up that you want some clarification on, do feel free to ask questions. And then at this point, the applicant can rebut. And you can ask questions of the applicant and the staff at this point. Then you're going to close the public hearing. And when you close the public hearing, this is really your marking point. Okay, this is all of our evidence. This is our record, and no more evidence is going to be considered. Once the public hearing is closed, then you can start with your deliberations. You're not going to have any more evidence here, but this is a really good time to then lay out what are the facts here? What is important to us in making our decision? So, you know, your criteria, one of the criteria for your applications is there are unique physical circumstances or conditions that are peculiar to the affected property. So here you might talk about, well, Joe Smith commented that the slope of the property or the grade of the property is such that it's impossible to build a structure here. And going step by step through what you heard, that's really then how you're finding your facts that are important to your decision. Then it's helpful in your deliberation to go through the criteria and determine how each of those, how the facts apply to each of the criteria. This open deliberation really helps with one, creating, for me to create a resolution which supports your decision. And then should it be appealed, it would help the deliberation process would support your decision and help that you made facts based on the evidence, based on the record. You did your fact findings that way, and then you applied those facts to the criteria that's laid out in the code.
A
And
quick
so you're,
question
Yep.
to you, Jennifer, and to Miranda. When we're looking at issues, is there an aim prepared that lays out the issues, and in that aim, does town make any recommendation, or is that part of what we do?
So yeah, excuse me, when town does do our analysis, we will provide what we believe are those kind of findings of facts, our recommendation, and we'll always provide our statement of whether we feel it's appropriate to warrant a variance. And if our opinion is that they meet criteria. And so we did do that with some of the recent ones you reviewed. And then that is for the BZA to then discuss kind of really whether you agree with us or not, but we're going to provide that initial analysis from our perspective.
Got it. Okay.
and you don't have to agree with town staff. So there could be information that comes up in the public hearing that maybe staff wasn't privy to and didn't know about. And these standards are subjective, and so it's not a black and white decision.
Okay.
Okay, so I think I've talked a lot about what the record is for the hearing. But this is all that's kind of, we think of it as a box. Everything that goes into your box will be your record. And the aim is going to be part of your record. The applicant's packet that they submit is going to be part of the record, any public comment, any written public comment, and then the transcript of the hearing is going to be part of your record. And then, so the record is what the court would review in reviewing an appeal based on your decision. So this is what is the evidence. This is really what I've talked about. One of the last things I want to just touch on is, so a board member's statement or opinion, is that going to be part of the record? So if a judge in a hearing or in a trial were to say, I know that the murder weapon acts in this way. I mean, would that be part of the evidence? No, it's not going to be part of the evidence. It's only the witnesses who are testifying who can provide evidence to the court for either a judge or a jury to make a decision. So think about that when you're in your role, in a quasi-judicial role, and there have, you know, on some of the previous applications, there have been times where I've heard people make statements, and they're factual statements, and they, you know, I've heard some reliance on those statements to support a decision or to support maybe finding that certain criteria is met. If you have that information, you feel that there is certain facts that you think are important, ask somebody a question that will elicit that information.
I don't know if we're coming to it, Attorney Mattson, but essentially, are there evaluation criteria that we should have on a 3x5 card in front of us, the questions that need to be answered for us to make a good decision?
Yes, and that's going to be, it's the same for every application. And Miranda will have that in the AIM, and it's the criteria for the for a variance. So yes, that will be in front of you.
Generally, there's no way to work around it, and we go for the minimum variation possible, right?
Right. Yes, exactly. And that is one of the criteria. Yep. So here are the types of questions that are good questions to ask. These are general ways to ask your questions. You want to learn more information, clear up any confusion, ask questions that's tied to the application criteria. And when you get then members of the public who are speaking, try to understand how they're affected or impacted by the application. You know, if you've got somebody who is a neighbor, try to understand how this neighbor is associated with the property. Are they right next door? Are they 3 houses away? I think that information would be helpful for you to ask clarifying questions and find out those details. Also, you know, that's next one is obvious. Don't try to argue with the speaker. And then the last one touches on a comment that I made earlier, is don't ask questions that telegraph that you've already reached your decision. You don't want to insert your opinion into the question, because that will look like you've prejudged it. So next, going on to the criteria. this is, you want to judge the application by the evidence presented at the hearing and as applied to the criteria. The criteria is in the code, section 16-232. And one thing that's really important to know is that you, as the body who is interpreting and applying this criteria, is that you can interpret the language of the criteria. What does it mean? So here is a criteria. I don't know that I want to spend a lot of time on this tonight. Unless you have any questions or want some guidance from me as far as how would you interpret something?
One question, there's 5 criteria here. Where do we usually spend most of our time discussing? Or is every case so different that that's not a good question?
I think it's probably the first 3.
Okay.
And maybe the third one. I mean, the last one is if the variance if granted is a minimum variance, it will afford the relief. So the first one is looking at really the conditions of the property, and are the property conditions unusual so that the particular code section shouldn't be applied to that property. And then the second one is, it ties into that. So as the physical circumstances or conditions of the property make it difficult for the property owner to develop it in conformity with the code. And the third is that really that the condition of the property wasn't created by the applicant.
Okay.
Yeah,
we have, seems like most of the ones we've looked at over the years, we're in a town that's full of slopes.
Yes.
And it creates some weird lot situations sometimes. Dave, your experience with that?
Yeah, absolutely true.
Yeah.
Yeah.
So, and then the last one is, I'm sorry, go ahead.
I was just going to add one thing. So, I think you're seeing a lot of variances right now, probably more than ever, and BZA has gotten really exciting because of just that, Tom. There is no administrative authority to approve variances. So, say your minimum lot size is 1,600 and you're, 1,500, or you're very close. We still not going to approve it. We're going to have you go through the BZA process because it's in that owner's best interest to have the resolution, to have that caught or have that recorded so that there's documented proof that they are allowed to build on this lot, despite this fact that it doesn't meet, say, minimum lot sizes. So you're going to start to probably see more and more of those come forward because all the lots that are left, most of them appear to have some sort of non-conforming issue. And so I think that's why we will see the BZA be busier than historically has been, because we are running out of lots. And a lot of lots were weirdly subdivided, and we're not sure why, but ended up just creating all these non-conforming lots.
Okay. Yeah, that's helpful.
And the resolution is recorded on the property, just like Miranda said. So it might not be somebody who's actually going to build at this time, but has an interest in selling the property and wants to make it more marketable.
And so I presume if that were to happen, the title company would have access. This will pop up in their records going forward.
Yes.
Okay.
And the town would also keep it within in their records and their property file that this variance has been requested and granted. Okay, so I just put this here, conduct of the hearing again, to kind of book in what we just discussed and see why it's important that the hearing is conducted in this way, that you keep all of the questions and fact finding to the beginning of the process. And then once you've closed the hearing, public hearing, then you can have your deliberation and make your decision. You
Question
can
on the slide we just were on. If there's a point, there is public comment, right? There's a
Yes.
period of public comment. If somebody comes in and it's clearly opinion and it doesn't have much to do with the facts of the case, I presume there's a time limit, and does whoever's chairing the meeting have the right to steer it back towards the facts? and away from
Absolutely.
opinion?
Yeah,
Okay.
absolutely. You do have 3 minutes for public comment on variance applications. The chair of the meeting is always in the position to adjust that 3-minute time limitation.
Mm-hmm.
When I give a script to a chair, I like to break up public comment to those who are in favor of the applicant and those who are opposed, so that way you know right away when somebody is speaking where they lie. And it's also important for me to mention that you guys are judges here, and so you have the ability to weigh credibility, to factor in other things. If somebody's saying, I really don't like this variance, I don't think it should be approved because I don't like Joe Smith.
Mm-hmm.
That's probably not a comment that should be strongly weighed in your decision making because it doesn't go to the criteria.
Mm-hmm.
And you can direct people back to we're here really for a variance. We have specific criteria that we need to consider, and we would like to hear a comment that is related to that criteria.
Okay. Great.
Okay, so I'm going to move away from the conduct of the hearing and talk about the ex parte rule. So the ex parte rule is based on constitutional due process that requires a right to an impartial judge. This ex parte rule only applies to quasi-judicial matters, so it doesn't apply to legislative decisions. The BZA really isn't making any legislative decisions. Only the Board of Trustees makes those decisions. So for the most part, all of your applicants that come to you are always going to be quasi-judicial. And ex parte means on behalf of one party. So essentially what it is that you're getting information from one side without the other side being present. And again, if we think about it in a judge and a court context, the defendant would never talk to a judge without a plaintiff or the prosecution being present. That cannot happen. So an applicant cannot speak to you about a variance request before the hearing. They just can't. And you shouldn't hear this. You shouldn't hear any comments from the applicant. You also shouldn't hear any comments from the public.
It's kind of hard not to hear comments from the public. I mean, there's just 1,000 opinions out there.
Yeah.
And living in this town, everybody
other-
freely expresses them.
Yeah. I know that you're in a difficult situation, but it denies the other side the opportunity to know what you've heard and to be able to respond to that.
It just seems
So-
like it seems like an impossible position, but I guess we give it our best shot.
You do the best you can.
Yeah.
Okay.
So what should happen is when we know that we have an application and when you know you're going to have a hearing, Miranda or Britt will send an email to the BZA and say, hey, everybody, we've got this application, the ex parte rule applies. So it really starts at the time the application is filed. Conversations before the application is filed are not subject to the ex parte rule because an
And this-
application may never be filed. You don't know.
Well, I think my point was that there are potentially some very big changes coming to town, and fortunately, that's kind of flown over our heads up to the B or the up to the BOT. But it's entirely possible that some of the stuff could land in our lap, and I guess even though nothing has been filed yet, or may not be filed for quite some time, I guess we just still have to be. It's impossible not to hear stuff, but I guess we still have to be very careful about what we say.
Well,
Yeah.
and courts have said that you have, there's a demarcation point as to when the ex parte rule applies. And that is when the application is filed. So if you don't have an application, it doesn't
Okay.
apply.
Got it.
I think the 1/3 from the third up from the bottom is the one I had the most problem with, and I'm when I got started doing this, it makes sense to me to do outside research, but that's off limits.
Yeah.
It's got to be inside the box.
Well, right, exactly. It's got to be in your record box, your evidence box. And a way to get it in your evidence box is to ask a question.
Mm-hmm.
Yeah,
So
so you got to.
if we hear something that we know is not factual, and it's not refuted or brought up during the hearing, we can't act on it, or can't, I mean, because we already said we can't really steer the hearing to what we've heard or what we know.
Well, you can. So, for example, say you're aware of the property
Right.
where the variance is requested, and you know that the grade at the property is extremely steep, and nobody is mentioning this, but you know that that's the case. Well, ask the applicant that question. What is the grade at the property? Or ask town staff.
Okay.
I've got a question on that one though. So when there was the last fence variance that we were talking about over at Knotted Root, I took a drive by to personally take a look at the fence to see if you could actually see traffic on the Peak to Peak Highway. So is that going against the rule that we have?
Yes, it is.
Even though one of the applicants was saying it obstructed vision, it obstructed the view, and
Well,
if that were, whether it was true or not, is we have to just take what is stated on one side without looking. We can't go look for ourselves.
You can, but you need to get that in. You're not a witness. You're judges.
interesting.
You're not
Okay.
witnesses. So you need to get the information from somebody else other than you. And it's
Okay.
Well,
okay.
this situation, I believe, was the applicant.
Oh, you broke up.
Yeah.
You broke up. Try it again, Steve.
Just broke up there. Okay, so the particular issue at that point was that a town resident had said that there was going to be a view obstruction to any of the traffic that was coming down. The applicant, I believe, said that there was not an obstruction to traffic, a visual obstruction to traffic. So I went by several times actually to take a look at it myself and see. So the proper procedure there would have been then notifying town staff, or how do I go about?
Yeah, I mean,
doing
one
that?
of the things you could do is you could have asked town staff if they had done an evaluation of that
Okay.
concern. Have you looked at whether the fence will impact a view for traffic? And I
Okay.
would suspect that at that point, maybe the answer would be we haven't.
Interesting. Okay.
But then you can take it the next step. And you can say, well, I think that that's important. It's important maybe you'd have to tie it to one of your criteria. And I don't want to spend a ton of time on a specific case, just so that.
Yeah, I don't think we need to. I think it's this one, that point to me is one of the hardest things to get used to and make sense of.
Right.
Because
So
we're a small town and this is right in our
Exactly.
face.
yeah, and
Exactly. And that's,
I
yeah.
do understand that. So then, in that situation, if town staff didn't have the information, you can continue the hearing. And you can say, I think that this is important information for us to know. And I would like to have somebody investigate that.
Okay.
And so then
So-
you continue it to a specific date. You continue your hearing, say, to the next month or whatever date works for you, but you continue it to a date certain to gather that evidence so that somebody else can be providing the testimony and evidence and not you as the judges.
Okay, and then the second from the bottom, elaborate on that. It's just got a question mark.
That's the same thing. That's the
Okay.
same thing. So what Steve did was essentially a site visit. Is he
Mhm.
gathered information, went out and did some research on his own, which is what you would be doing with the site visit.
I did the same thing.
Yeah,
Mhm.
it's okay, but
Guilty.
you can't rely on information that you've discovered in the site visit.
Oh, it can't be brought into the
Without-
box.
Yeah, you gotta bring it into the box, and the best way to bring it into the box is to ask somebody a question.
Okay,
Okay.
got it.
That makes sense. Thank you. I appreciate that.
Mhm.
So just touching base on that same topic, if whenever we receive our packet from Miranda, and if we had that same, if we felt the need to do a site visit to see if the view would be obstructed on that road, same example, could we then ask Miranda or other town staff to then drive out to the site and do a site visit and have that included in the deal without us doing it? Does that make sense?
Yeah. Legally, I think that that's fine. So that's like the judge asking an assistant to do some research on a case or to get some information. Then you would want to bring up that site visit or that research that staff did in your hearing so that you get that into the evidence. I would like Miranda to just comment on logistically if she's okay with that.
Yeah, and I would say, and I think, maybe you all came at a weird time because we were going through a transition of staff. Typically, that's very much involved. We kind of had to, move forward in a relatively faster manner this time with those variances that came before you. But a site plan really is a part of our analysis. So you will see a much more thorough review and more like, and typically we take photos and give you a better sense of the property itself. There's a lot of lessons learned in kind of these last three. And so I do anticipate a much thorough, and complete application of a review on our end that does include that kind of site analysis.
It's all on you, Brett.
It's all on Britt. Right now we have Britt. So, I say that, I'm not talking about myself, I'm talking about Britt.
Yes. Yeah, and just to break that down further, I mean, this is something that I do a lot. I'm asking, specifically the streets departments, the utility departments, like along that line, like, does anyone foresee any issues with this matter? They go into depth, and it is mentioned on the AIM. And that is my plan moving forward. So you guys are prepared. I don't know how the last ones have looked, so I can't say, but that's our plan.
Which brings up a point. That's why I guess Andrew had to resign because it was double jeopardy. Do we need, as a board, are we short one member? Do we need to get one more?
You're short a regular member and an alternate still.
Both,
So really
okay.
Roger has to fill in. Not actually, you know, it's going to depend. It's either going to be obviously the board of trustee liaison or Roger. One or the other is going to have to fill in at all times.
Got it. Okay, understood.
So one of the follow-ups on that point is, say you get your packet for a variance request and you have a question. You wonder how the applicant would respond to your question. You can't, because of the ex parte rule, pick up the phone and call the applicant. What do you think of this question that I have? You also can't contact town staff to contact the applicant to ask the applicant to be able to respond to that question. Because that's still ex parte. You're just putting staff in between you and the applicant doesn't do away with that ex parte rule.
Could you say I'm unclear on something and I really need you to check this out?
Well, if it involves contacting the applicant, I mean, really, you just wait
No.
for the hearing.
Yeah.
Yeah. And you ask the
Yeah, there's
applicant.
matters of fact. Sometimes I'll look a packet over, and the matter of fact to me isn't established.
Yeah. Yeah, that's definitely possible. And, you know, you wait and get to the hearing. And if you can't get an answer at that time, then perhaps you need to continue the hearing so you can get the information to make your decision.
How far in advance of a meeting do we generally have the packet? I mean, if we get the packet, we find that something's or we feel it's not complete. Do we have enough time to ask staff to fill in the blanks?
Miranda, I think that's a question for you.
Yeah. I mean, I think, you know, our goal is always going to be to release the packets, you know, the Friday before a BZA meeting, which would give you almost a week, unlike the Board of Trustees.
Okay, yeah, a week is fine.
Yeah. You know, and again, lessons learned. We didn't release like Little Bear Village to you until Monday. There was a lot of like, oh my gosh, what was left off from a former staff member? What do I have to do? And so unfortunately, your introduction was probably not the cleanest to how we would normally process an application, but Britt would typically release it, say we're on our normal schedule, the first Friday of the month for the second Thursday meeting. So
That's
our
plenty of
ask
time.
though is that you review it quickly. Like if you're not going to review it until Wednesday night, you might be out of luck. We're not going to be able to rush out on a Thursday, but if you can review it, say over the weekend or Monday, then we'll have the capacity during the week to you know, provide more information if needed, or make sure that we're prepared to respond to questions.
That's fair. Thanks.
Okay, so just following up, concluding the ex parte discussion, ex parte contacts are likely going to happen. If they do happen, let Miranda and Britt know that they've happened. And a lot of times I find out Miranda will decide to bring me in and we figure out how to work through the situation. You can clean up an ex parte discussion that you've had. And that would be done at the start of a meeting. You would say, you know, a week ago, I saw Joe Smith and he was talking to me about the application, or he was talking to me about his property and some of the weird contours of the property and how it's difficult to develop. And it clicked that he had an application that I was going to be deciding for a variance. You can disclose all that at the hearing and describe the conversation as completely as possible. And then that gives somebody else a chance to say, oh, wait, you know, Tom he's biased. He has already heard this information and we don't think he can judge it fairly. But a lot of times that never happens. So cleaning it up at the start of the meeting, disclosing the ex parte contact, then you've shared the meeting and given the other side an opportunity to challenge you as a judge.
Okay.
All right, I'm going to go on to conflicts of interest. And this is the last topic that I have for discussion. So there's really two types of conflicts of interest, and these are both spelled out in state statute. And one is a conflict of interest that would affect your pocketbook, essentially. Will you benefit? Will you get a financial gain from making your decision? A conflict of interest that I could see happening on the BZA is if you are a contractor or engage in construction work and you grant a variance that would allow somebody to develop, and then you have the contract to do that work. That's a clear conflict. You can't participate in that decision.
Mm-hmm.
The other type of conflict is where this is really a very subjective conflict. And this is if you have a personal private interest in any matter and you're going to be making a decision on that matter, so that your personal or private interest is in conflict with your role as a member of the BZA. This situation might be that the applicant is your best friend, and there's no way that you would ever decide against your best friend, and you would always grant a variance for your best friend. Then you have a conflict of interest and you can't participate. This one is a little bit difficult to parse out sometimes. But I'm always happy to work through those with you and talk through any situation that you feel might be sticky. And let's just talk about it. One thing you can do is, if you feel that there might be an appearance of a conflict, but there isn't really an actual conflict, say you go to lunch every Tuesday with the applicant, but you're not best friends and you know the person and you're good friends with them, but you feel like you can judge the application fairly. You will hear all the evidence. You will listen to both sides. You'll listen to the neighbors. Then at the start of the hearing, you disclose that and you say, I know the applicant, we do get together, but I do feel like I can judge this fairly. And then again, you give the other side an opportunity to challenge you. And if nobody challenges you, you've provided the information that there is that relationship, that you have stated on the record that you will be able to judge the application fairly and you haven't prejudged. And courts have upheld members of the BZA and Planning Commission and Board of Trustees making decisions with those types of disclosures. So if you have a conflict concern, definitely talk to Miranda about it and she'll contact me and we can talk it through. Ultimately, especially related to the personal private conflict of interest, you have to decide whether you're going to be able to judge the application fairly. If you do decide that you have a conflict, you've got to disclose it as soon as possible. You cannot participate in the meeting. You've got to step down and you don't get a vote. And my recommendation is always that whoever has a conflict really can't be in the room during the hearing process, because you don't want to be accused of influencing other members of the BZA with facial gestures, or anything else, any other nonverbal gestures. That is the end of the training, and happy to answer any questions that you have.
I think we had a lot in transit. Guys, ladies and gentlemen, do you have anything else that's on your mind or that's not clear?
That covered pretty much everything that I had any questions about. So yeah, no,
Steve will never go over there again.
no, I will not. And actually, no, it does, to put it in the context of looking at it from a judge's point of view, and where you're not the lawyer, you're not gaining evidence, you are there to make a decision, move it up the ladder. Makes a lot of sense. It clarifies a lot of points for me. So I appreciate the time.
Yeah.
Steve, what you did was perfectly normal, happens all the time. And it, no big deal.
No, but I appreciate, just for future reference, how we conduct the same thing, and it's good just so we're all on the same page. So again, I appreciate the time.
Yeah, this is my third time through this, and I learned something every time. Anything else, folks?
Yeah, I think my takeaway from the question I had before was, like I said, given some of the contentious nature of the things that are occurring in town and around town, probably just best to keep your opinion to yourself and just shut up and go, okay.
And I won't be publishing anything.
No.
Okay. Well done, Attorney Madsen. Thank you.
Sure, happy to help. And I'm always available
you.
in case you guys have questions. If something comes up specific to an application, or a conflict or ex parte issue comes up, definitely reach out.
So
Good. Do we have other business tonight?
I was just going to say, I guess, just for all of you to be aware, we don't currently have any applications before us. We're normally set, of course, to meet quarterly. So our next meeting would be the second Thursday in April. We cancel those unless there's an application, but please know that we can always be reaching out early just in case. If we got an application, say today, we don't want them to have to wait until April. We would then reach out to you and ask you if you would consider doing something like tonight and adding in an extra meeting. But right now there's nothing on the horizon, but I feel like I'm using the term variance on the daily. So I'm sure some will come forward soon enough.
Yeah, I think one of the things that's been really helpful to make the BZA the lightest lift in town is a lot of these issues are just are decided very frankly up front when somebody brings an application in. I think Cynthia always did a good job of dissuading somebody from banking on hope. You basically have to be I think staff has been very good at being realistic with people when they come in on whether it's worth going for a variance and working on alternatives that don't involve a variance. So I really appreciate that.
Yeah, and that's definitely continuing. I think one of just the biggest challenge, like I mentioned, is just there are so, like, we've got a gentleman whose lot, there's just no way he can move forward without a variance. And so we're just seeing more and more of those where we dream with you as far as we can get you until it's like you're up against a wall because you don't meet non-conforming lot requirements. We're going to always try to see if, like, first, can we determine you're a non-conforming lot to begin with because you meet code, but those are few and far between as well.
I may have built on the last flat lot in town.
Probably. Now it's all downhill from here. Lots of time spent together is what that means.
That's right. That's how we got to know each other, Miranda. Okay, folks, any other business that needs to be brought up?
One more, just a reminder, there's no vice chair. So keep thinking as you spend more time on this board, if anyone's interested in vice chair. And I believe, Tom, you may be saying farewell to us for a different.
Yeah, I'm going to probably be shifting boards over to Planning Commission And we have a new board of trustee coming on who might be coming over here. Stay tuned for further news. It's been an honor.
That means we'll have to have a different backup to lead the meeting when Mark's not here. So also think about that as well.
I'm always here. Okay, so then I make a motion to adjourn.
I second the motion.
Let's go to a vote. So at 8:11, I call this meeting closed.
Thank you.
Thanks, Attorney Madsen.
Good night. You're welcome.
Can you hang on for a few seconds
Yes.
after I stop
Yep.
recording?
Yep.
Thanks.
Cool.